Hello friends, how are you? You might be quite well. Now in this video, points to be covered are: first one is police report is submitted disclosing commission of no offence before magistrate concerned. What should be his action? Second one, the topic covered is procedure to be followed when there is a complaint case and police investigation in respect of the same offence. Third point is, if a complaint is pending before magistrate, can the investigation be done by the police without permission from the magistrate? And fourth one is, what is protest petition? To answer all these questions, I have taken the idea from Criminal Miscellaneous Writ Petition number 10162 of 2022, in which the petitioner is Namdev Sharma, respondent is State of UP and others, and counsel for the petitioner Manish Tiwari, Kartikeya Sharan, and counsel for the respondent is Katyani and Manju Thakur, AGA, and Honorable Pankaj Naqvi, Justice, and Honorable Vivek Agrawal, Justice, are members of this DB. I will shortly tell what is the dispute, not going in details, you can take it from this judgment. The dispute between the parties is essentially relating to maladministration and misuse of the trust properties situated at Mathura, in which both sides are trading allegations against each other. Now, the various judgments I will quote in these are Apex Court judgment in Avinandan Jha versus Dinesh Mishra, AIR 1968, Supreme Court 117. Second one is HS Bans versus State of UP, AIR 1980, SC 1883. Third one is India Carrot Private Limited versus State of Karnataka, AIR 1989, SC 885. Then next one is Bhagwant Singh versus Commissioner of Police 1985 to SCC 537. And last one is Vishnu Thakur Tiwari versus State of UP 2019 8 SCC 27. Now I will discuss the power of magistrate under section 110. The first power which this section gives is, he may reject the report, means police report, and proceed to take cognizance on available materials. Second power is, he before accepting the report shall put the informant to notice as to why the closure report be not accepted, who would be at liberty to file a protest. Third power under this section is, he may take cognizance on a protest as a complainant, as a complaint. He can consider his protest application as a complaint. Fourth power he is having is, he may not accept the report and call for further investigation. And fifth one is, he while rejecting the protest may accept the final report. So the flavor of section 2010 is, section 210 is Section 210 of the Code is a self-contained provision which provides a mechanism to deal with such situations where a complaint case and police investigation in respect of the same offence is being proceeded. Now coming to again to section 10 to 10, procedure to be followed when there is a complaint case and police investigation in respect of the same offence. When in a case instituted otherwise than on a police report, which we can say a complaint case, it is made to appear to magistrate during the course of inquiry or trial held by him that an investigation by the police is in progress in relation to the offence which is the subject matter of the inquiry or trial held by him. The magistrate shall stay the proceedings of such inquiry or trial and call for report on the matter from the police officer conducting the investigation. He will stay his own trial and ask the police to IO to submit his own report. If the report is made by the investigating police officer under section 173 and on such report cognizance of any offences taken by the magistrate against any person who is an accused in the complaint case, the magistrate shall inquire into or try together the complaint case and the case arising out of the police report as if both the cases were instituted on a police report. And third one is if the police report does not relate to any accused in the complaint case, or if the magistrate does not take cognizance of any offence on the police report, he shall proceed with the inquiry or trial which was stayed by him in accordance with the provision of this code. That is, as per provision of 2 CRPC. So, a perusal of the above said provision indicates that in a case which is instituted on a complaint, the magistrate is made to appear during the inquiry or trial, that a police investigation is also in progress in respect of the same offence. He shall stay the proceeding of the complaint case and call for a report from the investigating officer, and upon receipt of such report, if he takes cognizance of the offence against a person who is an accused in the complaint case, both the cases shall be tried together as a police case, and if the police report is not related to the accused in complaint or no cognizance has been taken, then complaint case shall proceed in accordance with its own law. Now coming to view of the honorable bench. What the bench said, we, in view of above provisions, are of the considered view that as a complaint case and a police investigation against the petitioner are being proceeded in respect of the same offence, the provision of section 210 are squarely attracted, and thus the contention of the learned senior counsel for the petitioner that the provision of section 210 would not be attracted as the proceedings had originally not arisen on the complaint, rather on an FIR, is liable to be rejected outrightly, as the cognizance of the offence was taken on a protest. Now, Apex Court in Vishnu Kumar Tiwari, what it said, wherein it is held that if a protest petition fulfills the requirement of a complaint, the magistrate may treat the protest as a complaint and deal with the same as required under section 200 read with section 202 of the code. Now, during the proceeding, senior counsel has submitted so many submissions. The next submission of the learned senior counsel is that even though the matter is pending before the magistrate, yet police investigation is being carried out on without any approval of the magistrate, which cannot be done as per law. This submission appears to be attractive, but deserves to be rejected only on the premise that Section 210 of the Code itself contemplates such a scenario wherein the learned magistrate is vested with the power to consolidate and proceed as a police case while staying the complaint proceeding and after calling a police report from the investigating officer. Now, there are few judgments on the issues, the judgments of the learned single judges and decision of the apex court. One is Dharmendra Swamy versus State of UP of 2007. Second one is Harkesh versus State of UP. Third one is HS Van India Carrot Private Limited case. Essentially relying on Avinandan Jha that magistrate is not bound with the conclusion of the police report, finding that no offence is made out and that in an appropriate case the magistrate can take cognizance under section 190 subclause 1A on the basis of protest petition, which is an undisputed position. Coming to the decision in AR Antale versus RS Naik, AIR 1984 SC 718. This decision deals with an issue involving a private complaint lodged under Prevention of Corruption Act 1947 before a special court, wherein the apex court inter alia held that special judge was competent to take cognizance on a private complaint. So coming to the ultimate analysis, the bench said in the ultimate analysis, we are of the view that orders impugned relating to transfer of investigation and handing over the cases to the crime branch do not suffer from any error apparent on the face of this record. Accordingly, the writ petition is dismissed. The order dated is 1st March 2021. Chandra Vivek Agarwal, Justice, and Pankaj Naqvi, Justice, were both members of this bench. So, friends, in the last, thanks for watching. See you again. If any mistake done by me, please forget and apologize me. Always in your service. God bless. Thank you.